Good afternoon, everyone. Now it's almost near lunchtime, so I'll make it very quick, hopefully. My name is Mooni, and I'm a foreign attorney at Shin Kim, which is one of the top law firms in Korea, with a very robust and dedicated team for blockchain and digital assets. So today I'll give a quick overview of the regulatory landscape in Korea, which basically consists of three pillars: AML Act, Security Token Guideline, and User Protection Act as of today. So the AML Act has been amended back in March of 2021, and it was amended to basically expand its scope of application to virtual assets. And next up in the second pillar would be the Security Token Guideline that was issued by the Financial Services Commission, and basically providing more guidance on characterization of security tokens, and also its plan to basically amend the securities laws to account for virtual assets of securities. And in June of 2023, so just a couple of months ago, the Bill for Protection of Virtual Asset Users, which I'll just call as User Protection Act, was passed at the plenary session of the National Assembly, and it will become effective, it'll be actually July of 2024. So with those three pillars together, there are still pending discussions around a more broader and tech-informed legislation for a framework act, but I'll just briefly touch upon that at the end. So the AML Act was the first to regulate virtual asset service providers in Korea, and it was the first to basically define virtual assets and also virtual asset service providers. And the User Protection Act actually adopts a similar definition. So. But the thing is, the definitions are very broad in their language. So virtual assets are defined as electronic certificates with economic value that are not otherwise regulated under other laws, which is very broad. And also virtual asset service providers are also defined to cover those engaging in selling, purchasing, exchanging, transferring, keeping, or managing, or brokering. So that's a very extensive definition for VASP and virtual assets. But fortunately for the industry, the regulators have issued their guideline shortly after introducing the AML Act to actually require only major VASP to this de facto license requirement that's imposed under the AML Act. So major VASPs include centralized exchange service providers, custody service providers, and also wallet service providers. So contrary to the very broad definitions under the AML Act, there are only 37 VASPs that are registered in Korea. So under the AML Act, basically they are striving to impose anti-money laundering obligations on those registered VASPs. So they're required to do STR and due diligence and so forth. And as we have a lot of people from overseas in this space, I just wanted to note that Korean regulators are quite active in enforcing their authority against foreign VASPs who are actually targeting and marketing towards Korean users unregistered. So that's something to keep in mind, that if you're deemed as doing business in Korea, then you are subject to the Korean laws. So AML Act, it happened 2 years ago, 2021, but as the name suggests, it serves the anti-money laundering purposes. So there are shortfalls in terms of addressing like some basic questions that comes for virtual assets. And so thankfully, we recently got the Financial Services Commission, which is the responsible authority for virtual assets in Korea, to issue the Security Token Guideline. This is quite recent, February of this year, and it basically gave their first official guidelines on how to characterize security tokens, and first time to actually define security tokens as a new form of digitized security based on DLT. And also, it was basically providing their guidelines on how they think we can distinguish between securities and non-security tokens. And another important feature of this guideline issued in February 2023 was that it also included the FSC's plan to amend the securities regime, including the Capital Markets Act and the Electronic Securities Act, to actually account for security tokens. And some of the features include establishing I actually forget the exact name, but something like issuer management institution to account for issuance of security tokens for those registered institutions without having to go through traditional securities firms. And another feature would be basically allowing and establishing license for OTC brokerage of security tokens, establishing markets for security tokens to be traded, and so forth. So they issued a plan to amend the laws over the course of the coming year and so forth to account for the securities to be recognized, issued, and traded and distributed in the securities regime in Korea. I have the Howey test again. So just to have a backdrop of the entire discussion, Korea actually adopts a very similar securities regime to the United States. And with that, the investment contract becomes the key issue. And we actually have a very similar test to Howey test under the Capital Markets Act with the material departure on with a reasonable expectation profit element. So contrary to the US, we actually have a narrower element where we actually need indication of contractual right with entitlement to profits or liabilities. So with that, and in the Security Token Guideline, the Financial Services Commission actually focused on the first two elements under the Capital Markets Act, the indication of contractual right, and also the efforts by third parties. So they actually did a very extensive, gave an extensive guideline on how they think they should be interpreted, including some examples. And it basically gave a turning point for everyone in the industry to have some kind of predictability, which was not present. Because before then, we all knew that there's going to be some aspect of securities law coming into play, but we are just focusing and trying to interpret how Capital Markets Act would be interpreted by the regulators. Now we have some answers from the regulators directly. So, and as Greg mentioned, with respect to the Howey test, case-by-case analysis is always highlighted for this for under the Capital Markets Act as well. So totality of circumstances and each phase of the token should be analyzed to make sure that there is a security or non-security. Oh, okay, I'm really bad at this. There. And the third pillar and the last but not least was the User Protection Act. So it was the first law in Korea to specifically regulate virtual assets, and it will be effective July 7th, I think it was 17th, that's a wrong date, of next year. So the key objectives of this law was to basically safeguard user assets. Basically, User Protection Act is protecting users and making sure that there is no unfair trading activities that will be in the virtual asset industry. This was more of a very prompt reaction from the regulators after a few incidents that we had last year. And it was an accomplishment for the regulators and legislators to actually have this passed in a relatively short time period. And just to get into some more details, the virtual asset and virtual asset service providers are defined generally the same as in the AML Act, except that the bill excludes CBDC, and AML Act will also be amended to be aligned with these definitions. And they look to protect users' assets by requiring some deposit protection measures, safekeeping of virtual assets, making sure that there is insurances in place, and also there are monitoring transaction records throughout their businesses. Regulation of unfair trade practices, I think most of them are basically mirroring what are regulated. If the tokens were security tokens, they are basically same actions that are regulated under the Capital Markets Act, but they did actually take into account the characteristic of virtual assets by that they added that issuers should not be self-dealing with whatever they have issued. So, and monitoring abnormal transactions also are added. And I just wanted to highlight that there are going to be quite heavy sanctions for any violation of unfair trade practices. So it includes imprisonment and criminal fines and administrative fines up to 3 to 5 times fold, and also there are going to be aggravated punishments in case the amount in violation exceeds certain thresholds defined under the regulations. Administrative fines would also follow. So we are going to see some more development going forward, given that the subordinate regulations, enforcement decrees, that's going to come up with like detailed thresholds, amounts, and so forth, are still being prepared by the regulators and legislators. But so we probably have a pretty exciting year going ahead for the lawyers and the regulators and legislators. So I have the last slide, so I probably should run fine within the time. So going forward, what to expect in Korea. Security Token Guideline, I mentioned that they will be working to amend the existing securities laws, so that will happen, and that will come as subordinate regulations as well. So the details must be monitored. And we will be seeing precedents being accumulated from courts and regulators based on the guidelines, also amended laws. So that's something to definitely look out for. And there are continuing to be the discussions around the new Framework Act and the need for such more tech-informed legislation is widely shared by the regulators and the legislators as well. And the FSC has actually named it the second-level legislation for virtual assets that's on their next agenda. But timing-wise, from my personal take, is that it will probably take at least the time it took for the User Protection Act to come into place, which was at least a year or two. And probably there is an added layer of complexity given the need for global harmonization with other major jurisdictions and so forth. So probably right now for the businesses, best time to make sure that you have the compliance review going on in advance of the User Protection Act becoming effective next year. And I'll be happy to take any questions afterwards. Thank you very much for your time.